Hello all and welcome to this edition of the TDW Tech Bite. Today I'm going to do the first part of a two-part series on mergers and acquisitions in a downturn. Now you might be asking yourself, mergers and acquisitions in a downturn, isn't that a contradictory statement? Well, actually not really, because businesses have to be bought and sold at any given time. So if you look at the present conditions, now there is assets that are good value, nice bargain. And if you've got a strong balance sheet and you're able to go forth and multiply by acquiring businesses, then now is a good time to do so. Likewise, if you are a business that is looking for an exit, well, now might be the time to accelerate that exit simply because the future economic conditions are that bit more uncertain. So M&A right now is very much a topic under the spotlight. So in this particular session, let's turn the spotlight to two topics. I'm going to speak about issues you might need to think about if you have sold your business and the deal has closed. And I'll also speak about a deal that is in that twilight zone between signing and closing. Firstly, if a deal has closed, doesn't that mean that you can just go and sit under a palm tree and that everything is all hunky-dory and you've done your job? Well, what happens if you have closed just this year and your signing was in the early months of this year? You might want to go back and look at the warranties you gave as a seller in the share purchase agreement to make sure that the promises you made about the condition of the business were actually correct. Did you know everything that was going on in your business at that time? Because it was a fast-moving period of time in the history of the world. So that might be one area of concern that is on your mind right now. So do look at those documents and check those warranties. Also, if you have an earnout as part of the consideration mechanism in your agreement, or some element of deferred consideration, you might want to check the terms and conditions of that earnout or deferred consideration. What might have looked like a rosy deal 6 months ago might be less rosy now, and that might be good information for you to know as these circumstances evolve. Now, if you are in the twilight zone between signing and closing, there are a couple of concerns that need to be addressed right now. The first is, usually you split a signing and closing in an M&A deal because there's a third-party consent or approval that you need to get. Maybe you need to go to a regulator, and the regulator needs to approve the change of control. Well, regulators have a lot of things on their mind at the moment. It might take a bit of time for that approval to come through. Do you have a long stop date for a hard closing? What happens if that long stop date passes and you haven't fulfilled the conditions? That could mean the deal is off. So you might want to check the long stop date. You might want to check the conditions to closing, and you may need to renegotiate those dates and timelines and those conditions. The other serious issue for that twilight period is what's called a MAC clause, or a material adverse change clause. This is a clause that allows a person to cancel the deal. So the buyer can cancel the deal if there's a material adverse change to the operations of the business between signing and closing. Now that sounds, a very vague and general and potentially dangerous provision. Nonetheless, the courts have had a long track record of experience at looking at how these provisions are interpreted. There are some principles that you can look at and apply. Firstly, it has to be a material adverse change based on something that wasn't known at the time you signed the agreement. It's something that happened after signing. Now, that might be the case in the current situation, but it may not always be the case. Also, sometimes there are carve-outs from the material adverse conditions, and one of those carve-outs might well be things that apply generally across the entire economy. In other words, it is not something that is specific to the conditions of your business. It's something that is more systemic, like, for instance, a pandemic. And there may be other things that you would look at also. It has to be something that is significant, substantial, and serious. And it has to be something that is durationally significant. Nonetheless, MAC clauses are the kinds of clauses that many deals and many participants' deals are looking at very carefully to try and measure and assess the risk of whether or not that will allow a buyer to cancel the transaction without any punishment for doing so. So check that clause and tune in for the next session when we'll be speaking about problems to be overcome in M&A deals you want to execute now.